Good morning, everybody. Welcome to this morning's webinar. My name is Maxwell Okello. I'm the CEO of the American Chamber of Commerce. Before we begin, just some quick pointers. The session will be 1 hour long. The audio and video will remain muted. Your audio and video will remain muted during the course of the webinar. After this brief introduction, we will have a presentation from one of the panelists today, whom I'll be introducing shortly, after which we will have a panel discussion and a Q&A with the audience. If you have any questions, please type them in the chat, the Q&A tab, sorry, the Q&A tab, not the chat tab. Please note this, the Q&A tab at the bottom of your screen. I may call on some of you to address or field your questions directly to the panelists when we get to that point. So ladies and gentlemen, we are facing a period of rapid and significant changes to how we interact with each other, work, and do business. One of the more obvious impacts of COVID-19 is the increasing reliance on technology to bridge the gap and help us maintain some semblance of continuity in all aspects of our lives. The great debate surrounding the adoption of technology has been its perceived invasive nature and ability to rob us of our personal privacy. The amount of personal data we put out there knowingly and unknowingly by using a lot of modern technology has often been referred to as frightening. The global movement to curb this trend and give users a measure of comfort has seen many countries pass data protection and privacy laws. In November last year, Kenya enacted its Data Protection Act 2019, modeled substantially on the European Union's General Data Protection Regulation, or the GDPR as it's known, to provide a legal framework for the right to privacy. This act created wide-ranging set of new legal obligations for business and organizations with respect to personal data, which they collect from customers, employees, and third-party suppliers and service providers here in Kenya. Some of the questions we are all asking ourselves are, how does this act protect us? What are our individual rights with respect to the collection, the use, the access to, the disclosure, the storage, and the security of our personal information? What obligations do we as businesses have with respect to the protection of the personal data of customers and employees that we acquire? What can we do as businesses to be compliant and to prepare for the future where we'll be faced with even greater disruption posed by technology and more demands for privacy? And indeed, as it is with the situation that we're all finding ourselves in, we're really having to do a lot in this virtual space and share information. And I believe that this specific conversation this morning is something that we're all keen to really understand better what the Data Protection Act requires of us as businesses and as individuals. And to help us answer some of these questions and unpack today's conversation, we have with us today, and I'll just very, very briefly introduce them. They'll introduce themselves appropriately when it gets to the panel discussion that will be moderated by Joe Githaiga. So we're joined by the CEO of the National Communications Secretariat, Engineer Daniel Obam. We also have with us the Senior Vice President, Compliance Risk Management and Compliance Risk Management Head at Citi, East Africa, Yvonne Muturi. We also have with us Commercial Attorney, Emerging Markets at Microsoft, Otilia Piri. And we have Joe Githaiga, who is the Director and Head of Regulatory Compliance and Advisory at PwC, who will also be making a presentation to us shortly, and will be moderating the panel discussion. So moving on to that, I just want to say a few words about Joe before I hand over to him. Joseph Githaiga, as I mentioned, is the Director and Head of Regulatory Compliance at PwC. He is also an advocate of the High Court of Kenya and an accomplished corporate lawyer and compliance professional with over 20 years post-admission experience. Joseph has knowledge and experience in a broad range of areas, including financial services, compliance, corporate governance, private equity, joint ventures, M&A, capital markets, competition law, and wealth management. He's also previously worked with the business compliance function at Standard Chartered Bank and in private practice with Coulson Honey, now known as Bowmans. So without much further ado, I want to hand over to Joe to kick off this morning's webinar. Thank you. Over to you, Joe.
Thank you, Maxwell, and good morning, everyone. Pretty much that introduction from Maxwell gives you a bit of background context to me, so I'm not going to delve too much into detail about that. What I propose to do today is just give you an overview of the Data Protection Act 2019. There's a lot in the legislation, so today's session is not really going to give you the full flavor, but at least it will highlight some of the key aspects that you and features of the legislation that you need to understand. I'm going to run that over a period of about 20 minutes. Included in that presentation is also going to be just some tips around the considerations you need to be taken into account if you want to develop a privacy program to manage the risk arising from this legislation. And then after that, we can move on to the panelists, and we will try and just speak on select issues around the legislation, which we can have a conversation about before we then open up the session to questions from the participants. So I'll just put up my presentation on the screen. I hope everyone is able to see that. So just a bit of context. Why is data protection? Yes.
Joe, please go on presentation mode. Turn it on to presentation.
Got it. Okay, great. So just a bit of context. Why is data protection and privacy important? Why is it a topical issue at this point in time? I think on the one hand, some of those points have been alluded to by Maxwell. Most of us are now very interconnected. From a business point of view, data is the new oil or the new gold. The value of data for the purpose of increasing business efficiency as well as generating new income streams has increased exponentially. And then technology has enabled that data to be able to share very widely within a very short period of time. And it's so ubiquitous that most oftentimes when you put your information out there, you're not really thinking beyond the immediate need for which you're sharing your data. You know, if you're on social media, for example, it's really about sort of telling your friends, this is what I did on the weekend. But you're not quite sure who else has access to that information. It's when you step back and have to think through that then you realize that there's potential risk of people unrelated to you having access to your information. It's important to also understand that privacy is a fundamental human right. It's guaranteed under our Constitution, under Article 31, and it's also reflected in the United Nations Human Rights Charter. It's not an absolute right. It is one of the rights that you would enjoy as a citizen under the Constitution, but it must be weighed up against other rights and freedoms. Increasingly, we've seen global regulators, privacy regulators, enforcing this type of legislation and imposing heavy fines on breaches. And so, in line with global trends, we can expect that in Kenya, this is also something that's likely to happen as we become more and more regulated under this legislation. Also, again, relevant to businesses, your customers expect that when they give you information, they trust you to use that information properly, and for the reasons that you have told them that you're going to use that information. And so if there's a breach of privacy, surveys have shown that for the most part, customers will start avoiding engaging with businesses that do not promote or that do not protect the information. So there's a real business need for you to understand that data privacy breaches hurt your brand and hurt your reputation. Getting into the act itself, it's important to just familiarize ourselves with some of the key definition. There's a concept of a data subject. That's really you and I, so a natural person, a natural living person about whom personal data is collected and processed. So every one of us participating in this call is a data subject. There's a concept of data controller. Now that's you putting on your organizational hat or your business hat, your business owner hat. So a person or entity that determines the reasons or purposes and the means of processing personal data is known as a data controller. So you find that the majority of the obligations under the legislation attached to a data controller in terms of how they handle the information of the data subject. A processor is essentially a service provider that a controller engages to process personal data for them. So if you think about it, if your job is to supply services to institutions, and as part of providing those services, institutions let you or give you access to information they hold about their customers, that essentially makes you a processor. And the difference between the processor and the controller is that the processor doesn't really determine the purposes for collecting the information. They simply receive instructions from the controller around what to do with that information for the controller's own purposes. So when you think about cloud service providers, when you think about maybe marketing agencies that you want to run marketing campaigns for you, or when you think about research houses that you want to do some analysis on your behalf or as an organization, those would be your processors or examples of your processors. Personal data is literally any information that can be used to identify a data subject. And so, it ranges from your name, your address, where you live, who your next of kin are. But it can also refer to things such as your email address, and also your geolocation. When you're walking around with your mobile phone, and if somebody's able to use the information on your mobile phone to track where you are and track your movements, all that is information that relates to identify you. The concept of processing is really anything that you can do with personal data once you collect it from a data subject. So it involves the collection, storing, retrieving, who you share it with, when you alter it, when you delete it, all those sorts of activities. There's a special category of personal data known as sensitive personal data, such as your health status, your race, your political beliefs, your conscience, biometric data. This is essentially information that could be used, if misused, can affect your fundamental freedoms. So it poses greater risk in terms of unauthorized access and use of this sort of information. The Act sets out a number of principles, underlying principles, which pretty much provide the framework for how the legislation is drafted. So it's important that any processing of personal data must be done in accordance with your right to privacy. It must be lawful, fairly and transparently processed, basically meaning you need to disclose to me what it is that you want to use the information for. If you're collecting it, you need to tell me what you want to use it for, how you propose to secure it, and who you tend to share it with. It's that idea of being transparent with me about how you're going to use that information. And of course, using lawful means to collect it and to otherwise process it. the law requires that as a controller, you only collect information for a specified and legitimate purpose. So what that will mean for a lot of organizations is they'll need to actually sit down and set out the reasons why they collect information from their customers, information from their employees, or any other individuals that they interact with as part of their activities. Then you're only supposed to collect that information that is limited to the purposes that you collected it. So don't ask for details that you don't need for the particular service that you are providing. Limit yourself to only that which you need to perform the activity that you're collecting the information for. Ensure the information you collect is accurate, and have a process for reviewing it on an ongoing basis, just to ensure that it's up to date. Only store it for as long as you need it. The Act doesn't prescribe any retention period. Depending on the kind of organization you are, and if you're in a sector that is regulated, the other laws might prescribe how long you hold data for. But otherwise, it's really up to the organization based on your business and organizational needs. If you want to transfer the information outside of Kenya, you have to ensure that you've put in place safeguards. And it may mean that you have to assure yourself that whoever you're sending information to outside of Kenya, if it's a service provider sitting outside of Kenya, that they themselves have actually put in place a framework for protecting personal data. In some circumstances, you're required to obtain consent from the data subject before you transfer the information outside Kenya. Also, only collect the information that relates to family or private affairs if you've actually given a valid explanation to the data subject. There's a regulator that is to be set up. Currently, one is not in place, but it is anticipated that before the end of the year, one will probably have been appointed. And that's one of the issues, I guess, we're going to touch on during the panel discussion. Some organizations are going to be required to register with the Data Protection Commissioner, the regulator I just referred to. It will very much depend on the industry that you're in. If you happen to be an organization that processes a lot of sensitive personal data, I'm thinking schools, I'm thinking clinics, hospitals, insurance companies, my own view is that those will probably be required to register. And also depending on the amount of personal data that you process on a day-to-day basis. The Act confers certain rights on us as data subjects. I have a right to be informed by a controller regarding what use they're going to put my personal data to, which means that that's an obligation on the controller to be able to come up with that list of purposes and inform me. I have a right to access the information that you hold about me. And you're required to provide it to me in a portable, machine-readable format. I have a right to object to you processing any or all of my information. If I'm not happy, if I feel that it is inaccurate, or it's no longer current, I can ask you. I have the right to ask you not to continue using that information. I also have a right to ask you to correct false or misleading information, and in some situations also delete it. Yeah? I have a right also not to be subject to profiling, automated profiling. Basically, in this day and age, you find that when you're online, organizations will use cookies and other technology tools to track your habits and your trends and try and create a profile around you. Now, if I use that sort of information to then make certain decisions that affect your legal rights, then you have a right to know that I'm actually profiling you. And so that's what that requirement is about. And then I have a right to actually ask you for my information and transfer it to another service provider. It may be that I'm unhappy with the services that I'm getting from you. So I come and I tell you, a good example might be in the banking industry. I want to change my banks. So I have a right to go to my current bank and insist that they transfer my information to the bank that I'm going to. And so you have an obligation to comply with that request within 30 days unless you engage a regulator and you get an extension. This is one of those issues that's probably going to create quite a bit of a headache for a lot of organizations, depending on how you currently hold. Firstly, whether do you know what kind of personal data you hold and how you're holding it. The law requires you to have a lawful basis for processing personal data. Either you have the consent of the data subject, and that consent must be explicit. So silence is not consent in this case. It must be explicit, it must be clear and unequivocal. Then if you are not able to establish a ground of consent, there are other grounds, but you have to show that such processing is necessary, and you base that necessity on the list of grounds that's highlighted on this slide in red. I think a lot of businesses will probably try and rely on legitimate interests. So you say, as a business, I have a legitimate interest in using this information in a particular way so that I'm able to provide the services that I offer to clients. But you still have to weigh that up against any risks to that personal information. Similarly, if you're obligated under a contract to process information in a particular way, so that you have a service that you need to provide to a customer you have a contract with, then again you can justify the use or the processing of their personal information on that basis. There's some further rules around sensitive personal data. As I said, this is seen as higher risk information, so you have to be a bit more careful around how you use this. Basically, if you can show that, so you basically require consent from the data subject, in the absence of which you then again establish a necessary ground, which have set out their legal claims, rights and obligations, vital interests. Particular type of data like health data has to be processed under the supervision of a healthcare provider. There's no definition of that. So, it could be a doctor, it could be a nurse. We expect that we'll probably get further clarification around that point. Or alternatively, it can also be processed under the supervision of somebody who is subject to a duty of law. Case in point would be bankers, for example. Where you're dealing with information of children, personal data, you need parental or guardian consent to process that information. And you have to ensure that what you do with it is in the best interest of the child. You're also required to have a way of verifying what the age of the child is as part of the controls you put in your organization. I mentioned earlier, if you want to transfer information outside of Kenya, personal data, you have to establish proof of safeguards. You should, in the case of sensitive personal data, also obtain the consent of the person. And in the absence of consent, then you have to establish one of the grounds of necessity listed in the legislation, again, which are set out in that slide. Other obligations relate to some of the, organizational measures you can put in your business. One key one is the appointment of a data protection officer. Not every business will be required to appoint a DPO, but for those businesses that actually process a lot of personal information, a lot of personal data, and they continuously monitor data subjects. And again, examples of this might be bank, insurance companies, hospitals. If you just happen to be in that type of business where you tend to use a lot of information, a lot of employee information, then you need somebody in place who can coordinate compliance with the legislation. And that's really what the role of the data protection officer is. Similarly, in some situations, you'll be required to undertake risk assessments. That's what they call a data protection impact assessment. If you want to use the information for a new purpose, if you want to use a new technology to process that information, you need to undertake a review to see how much risk it poses to the privacy of the persons whose information you've collected, the data subjects. And then you're required to put in place measures and procedures within your organization that embed protection of privacy within your organization. That's really what the concepts of data protection by design and by default are. So it could be, for example, using technology tools that pseudonymize or anonymize the identity of the person whose information is collected. Because when you sort of create that, when you delink, it means that somebody who's trying to hack into the organization and access that data will not be immediately able to know whose information that data belongs to. So it's a safeguard that you put in place, and so you have to keep thinking about that through the processes that or through your activities and your operations in your organization. In the event of a breach, you are required. There's a requirement by the data controller, so you as the business owner of the organization, to inform the regulator within 72 hours of such a breach. And then you're also required to inform persons affected by that breach about the fact that it has happened, and you're required to do so as soon as reasonably practicable. If you happen to be a data processor and the breach occurs within your activities, then you have an obligation to inform the data controller within 48 hours. I think the idea is that once the data controller knows, then they also have an obligation to inform the regulator. This set out the main penalties under the legislation. There are those that are court sanctioned, including fines and imprisonment. So for most breaches of the Act, there's a potential fine of up to 3 million shillings and a jail term of up to 10 years or both. Certain types of offences attract a higher fine, although the prison term is less, so 5 million, 2 years. And that's those sort of offences, for example, where you fail to collaborate with the regulator or to cooperate with the regulator. Or lying to the regulator is one of those sort of sanctions that attract a higher fine. If people are affected by the breach and they suffer damage, then they can also seek compensation, and the court can order compensatory orders. If there's certain equipment that has been used to sort of perpetuate that breach, the court can order that be forfeited. The court can also order that you stop processing information in a particular way. So that's what the injunction's about. And then, other than the courts, the regulator themselves, the Data Privacy Commissioner, has the power to also fine organizations that breach the legislation. And they can fine you the lower of up to 5 million shillings or 1% of the turnover of your business for the preceding year. It's an interesting way to sort of impose that penalty. In other countries, it's usually the higher of a monetary amount or the turnover. So you find that, for example, under GDPR, the penalty is the higher of 20 million euro or 4% of your annual turnover worldwide. So you can imagine under the GDPR, the consequences are much harsher than the consequences under our own legislation. I mentioned the GDPR, and Maxwell had, in laying the context, had mentioned that our law is modeled on the GDPR to a large extent, but there are some significant differences. And if you're the type of business that might be caught by GDPR, it's important that you also do some analysis and see the level of exposure. So under GDPR, for example, you're required to actually demonstrate that you're complying with the legislation. And so that means that you have to have a process in place, and so the amount of work that you need to do to protect yourself under GDPR is much more than what you do under our local legislation. As I mentioned, the penalties are much higher under GDPR. GDPR also requires you to keep a detailed record of how you process personal data. If you're going to appoint a data protection officer and you're subject to GDPR, then the requirement is that the DPO needs to be familiar, an expert in privacy law and implementation. That's not, the bar is not that high under legislation, and it may very well be because we're still new with our legislation. We don't have very many people who are familiar with this subject matter, but it may be that with time, that bar may be increased. Moving on to some practical considerations, I suppose if you're now going to put in place a framework to data privacy and protection framework, some of the things you need to consider, for example, what kind of personal data do you hold? Do you understand, how you hold it, where it's sitting in your organization? If it's in your IT systems, how is it being held? If it is in archives in a warehouse somewhere, how is it held? Do you tend to just keep information in files that anybody can just go in and have access to, and therefore exposes you to risk? If today you are called on by a regulator to show that you're complying with the regulation, would you be in a position to do that? Would you be able, for example, to comply with a 72-hour notification period if today the data protection commissioner was in place and asked you, if there's been a breach? Would you be able to provide that reporting? To meet that notification requirement within 72 hours. So what that then means is generally you have to start thinking through how you put in place the framework. And this slide here simply just gives you a simple way of visualizing what such a journey to developing a framework would look like. Firstly is obviously making yourself aware of this topic and what your obligations are. And then once you do that, you move on to trying to identify the kind of information that you hold. That's the whole data mapping and inventory set out there. And then you have to then start assessing. And then this is where you probably want a consultant to come in and help you. But you start assessing where the gaps are. Do you have a privacy policy? If you don't have one, then you need to put one in place. Do you have a means of obtaining and recording consent from your customers? If you don't have one, then you need to put one in place. So the gap assessment allows you to see where you have deficiencies currently in your business and where your key exposures lie, so that you're then able to develop a plan for correcting those deficiencies. And that's where you now get into the implementation roadmap. And then once your framework is up and running, and it may take you several months, if you're a larger organization, it's something that could exceed even 12 months. But then you have to have a process for ensuring that on an ongoing basis, you're monitoring that the framework is working. And it may be that the new regulations will come in, so you have to continuously update your framework to reflect changes in the law and also changes in circumstances. So my last slide is basically emphasizing that privacy risk management is a collective responsibility. Even if you appoint a DPO, it shouldn't be the role of the DPO to manage that risk by themselves. If this is something that requires support right from the board and management, other functions within your organization, everybody needs to come together to ensure that they understand what the requirements under the law are, that they play their part in ensuring that the relevant safeguards are put in place to protect customers and employees. Remember, this is not just outward facing. It's also imposing obligations on you as an employer to ensure that the information about your employees is also safeguarded. And similarly, if you're dealing with vendors and you're collecting personal information about those vendors, you also have an obligation to ensure that that information is safeguarded in accordance with the Act. So that sort of wraps up the formal presentation. And I think at this point in time, I'll just invite a discussion with my fellow panelists. And maybe just to start us off and give us a bit of context around, why do we have this legislation and why now? I would ask Engineer Obam to just give us, he was on the task force that recommended the adoption of this legislation. And it would be useful to understand from him what's been the journey to where we are right now.
Thank you, Joseph. I'm here on behalf of PS Jerome Ochieng, PS for ICT and Innovation in the Ministry of ICT, Innovation and Youth Affairs. The journey, as you recall, actually started quite way back when we had the Commission on Constitutional Commission on Implementation of the Constitution, which had actually gone quite far with the drafting of a bill. And at that time, it was envisaged that both the access to information and data protection would be under one constitutional body. But access to information was enacted ahead of the data protection. And because of that, because of Article 31 of the Constitution, which is quite brief, it was felt that it's necessary to have a legislation that actually delves further into the implementation of the issues of processing of data, personal information. Then secondly came the GDPR. As you know, many of our trading partners are actually Europeans, and the issue of adequacy is important. As we know, we have many companies, Kenya Airways, our flower industry, that trade with Europeans. So the GDPR requires that there's adequacy in jurisdictions that deal with the European, personal information. So based on that, and the third one, I think you mentioned, Joseph, the fact that data now is a very fundamental part of the digital economy. So it was felt necessary that we have a framework that implements the Constitution, facilitates commerce for our companies, and also helps us in the digital transformation of our economy. So the minister last year put together a task force that went through previous documents and came up with this framework. We went through an elaborate public consultation process. Some of you know that you gave in input. So I think there are some shortcomings that I've seen some people, not here, but elsewhere pointed out. But actually, this document went through a lot of public consultations. We specifically consulted with Ghana, Australia, the UK, the Council of Europe. As you know, the framework that the Council of Europe promotes for privacy and data protection differs slightly from the GDPR. So we looked at the Council of Europe. We brought in experts from there to also look at the work we are doing. So based on that, then the draft that was taken to Parliament was like what was compromised after those elaborate public consultations. To give you an update, since it was mentioned, as you know, the position for the Data Protection Commissioner, because I think there's a lot of discussion on that. I've even seen somebody suggesting it should be a wild, wild west because there's no data commissioner. The position was advertised. The deadline was 14th of last month. According to the Act, the Public Service Commission is allowed only 21 days to process the applications and then present 3 names to the president, who then takes it to Parliament. And then coronavirus happened. The applications were both online and physical. So the shortlisting now becomes difficult to do shortlisting online because you cannot meet more than 4 people. So what I've been told this morning by the PS is that the Public Service Commission told him yesterday they're actually doing the shortlistings now. And after that, now the other process of shortlisting 3 people, names to the president, then to Parliament for vetting. Maybe let me add, because that was mentioned, the issue about being a wild, wild west. I don't think so. I think the Act provides a framework for compliance. And if you look at the principles, those principles actually do give you a framework for managing or storing your data in a manner that should you be asked to comply, you are able to comply. there may be a shortcomings in that you don't have a specific, you don't have people designated as data officers, but I think that should not stop compliance with the principles of the Act. And I think the questions that you ask at the end of your presentation are very important, that in the absence of the Data Protection Commissioner now, it gives us an opportunity to actually look at our internal processes and prepare, because the Commission is a regulator. Regulators do enforcement. So we cannot say that perhaps because we don't have a policeman in sight, then we don't need to comply with the law as stipulated. I think it's important just to see what we can do now, so that by the time the regulator comes in, we are prepared to comply with any additional requirements. And I think for things that are missing, as you rightfully said, this could be tweaked. On the issue of not giving adequate, any time to enforce, I think in the GDPR gives some, I think 2 years.
The transition, yeah, you're talking about the fact that there was no transition period. Yes.
Yes. Previously, the European directive on privacy and data protection also took some time to be implemented. For us, we thought that immediately the Act comes into force and the Data Protection Commission is brought in, they can do some capacity building exercises so that this allows us together to move forward. On the last point, on why the difference between our legislation and GDPR on expertise in data protection. We did not have data protection in place, so we'd assume we don't have expertise in our institutions. So we have to build this capacity, and that's why it allows you to designate, be it HR, IT, legal department, to be the data protection officer as we build capacity to have them have expertise in this area. Thank you.
Okay. Thank you very much, Engineer Obam. I'll then probably get a perspective on one organization and how it has been putting in place a privacy program, maybe some of the challenges that they have faced. Yvonne, at Citi, you're a global organization. You're subject to privacy laws in multiple jurisdictions. In the context of Kenya, what has that journey been like for you? What are the main challenges that you've experienced in terms of applying the DPA to the Kenyan business?
Okay, thanks for that, Joe, and good morning, everyone. So I think, really at Citi Kenya, we've kind of been anticipating this piece of legislation for a while now. Obviously, on the basis of the fact that Citi is a global organization, we have businesses across a globe presence in 100 countries. And we did have the benefit of also getting a preview of the document through the Kenya Bankers Association as well. So, and I'm not saying this because Engineer Obam is on the line, but my personal view is that the document is actually quite, quite clear and quite precise in the way that it creates a framework for what is expected. Yeah. So I think, even for the non-lawyers in the room, it's an easy enough document to be able to pick up and kind of quickly understand as an organization what your obligations specifically are. So it's clear as a data, processor, as a data controller, what you need to be doing, as a data subject, what your specific rights are. But I think the part that's really going to be most critical, kind of looking forward, is how the regulations and the guidelines are going to be put forward. Because an organization like Citi and any other financial institution, I think it goes without saying that we are going to have to be registered by nature of the businesses that we run. But the question then becomes, if you're like Citi and you have a lot of kind of cross-border touch points, how does that vary vis-a-vis somebody else who is maybe just practicing within the borders of the jurisdiction, perhaps may not have as many kind of personal data touch points as a bank might have. So I think the operationalization of this is going to be, hugely important. Really, and for us, it comes down to considering client, right? Because data becomes an increasing and has become an increasing consideration in our relationship with our clients. It's very kind of front and center. So whatever program we're building has to be client centric, and clients are going to ask, so what are your privacy practices? what is it that you're doing about the information that you're holding, and the program then obviously also has to be transparent. So you need to be able to be clear about how it is that you're managing that. So I'm a compliance officer, so obviously that means second line of defense. But I would not be able to do my job if there wasn't kind of a clear kind of engagement from the first line, meaning the business. Yeah. So the model that we employ means that we actually have in-business privacy officers. Yeah. So every business line would have an in-business privacy officer that really would be the champion around, considering, if it's a new product, a new tool, a new technology, etc., considering where those privacy touch points are in that whole kind of information journey. And we wouldn't, as legal or compliance, that wouldn't be necessarily something that we would have intimate enough knowledge about to be able to clearly articulate. So I think kind of getting very early business relationship and knowledge, and transferring some of this knowledge to the business as well, so that there's that close interaction between the business and the way that they're rolling out new products and services is extremely important. So having an in-business model is important. The Act talks about things like the privacy impact assessment. Again, that's been something that we've been considering quite a bit, asking questions like if an initiative is new, we're processing data, first of all, what data sets do we have? Do you have somebody's home address? Do you need that home address in all honesty to be able to roll out this product or service? Is it an absolute necessity? Because even when you collect the data, there's an obligation once kind of the end of that relationship comes, that you have to consider how to, destroy or get rid of that information. So once you collect the data, there's a lot of responsibility that goes beyond just being able to provide a service. And I think there has to be kind of early consideration as to whether that information is really truly necessary as you're rolling out, different products and services. So there's been a lot of considerations. And I think the other one that a lot of organizations do need to think about is the point about legal basis that you mentioned, Joe. So there's the high threshold of consent and getting explicit consent. But I think our law does contemplate a scenario where you could potentially, process data on other bases. And we've spent a lot of time on that. And it's not something to kind of gloss over. I think that's going to be an important conversation, for all organizations.
Excellent. Thank you for sharing that experience with us, Yvonne. I'm pretty sure there'll be lots of other questions sort of flowing from that. Now, Ottilia, Microsoft has been quite key in helping customers all over the world create this program and create tools that help in managing the data protection and privacy risk. I'll just ask you just to describe for us a little bit around, how you've gone about doing this, how you're supporting clients with their privacy journey. And these concepts around privacy by design and default, they sound like fancy terms and technical terms. But in practice, what does privacy by design look like, or by default? And what are those sort of tools that you can embed into your organization that help you achieve that standard?
So as a cloud service provider, and with the amount of customer data that we process in our massive infrastructure across the world, we've had to have a privacy and security program in place probably since very early days from when the business started in this space. But what happened is that as we came towards EU GDPR, there was a need for us to enhance our privacy program, as some of the requirements under the EU GDPR really elevated what was required of us. And we took a decision as a company that we wouldn't just comply only for our customers within the EU, but we would work to ensure that our products and services that we roll out globally are actually made to the same exacting standard. So this meant that we went through an extensive process ourselves to analyze our business processes and enhance the tools that we had in place to ensure compliance with EU GDPR across our products and services that are available globally. And the areas that I think really our technology shines in some, you know, when you shared the roadmap of the steps that a company should take on that journey, in the area of understanding what's the personal data that you have. You know, what's your data estate? Where's that data sitting? Who has access to it? We have tools that enable you to go into your environment and identify where that personal data sits, identify where sensitive data sits, and then also the ability then to be able to classify that data. And in doing so, set controls on who can access it, whether encryption is required, and also how long it should be retained based on whatever the company policy is. So that's the second area that our tools are really helpful. And then also from a monitoring and or reporting and compliance perspective, there's the ability to be able to understand how data is flowing throughout your environment, through the whole life cycle. And you have a log of what were the touch points and what that data was used for. And the ability to have that log, as in that whether it's access logs or information around the processing, enables you to be able to at least show how you're complying. So that's one area. We went through the journey of having to comply ourselves with EU GDPR, and then went through an extensive exercise of mapping controls and features within our products and tools that could support compliance. What we're doing in the advent of the Kenya Data Protection Act is doing a similar mapping. So we're actually currently working with external consultants on reviewing the regulation, looking at the business requirements and ensuring that that's reflected in our controls and features within our products and services. Essentially, allowing our customers to have the opportunity to do the privacy by design that you're speaking about, or privacy by default, leveraging the tools in our products and services for them to be able to automate in some respects some of the management of their privacy controls within their environment. The second bucket of what we do, okay, so where we sit, we're a technology company, right? And that's really our specialty. We're not consultants, so we're not really able to take a customer through the end-to-end journey that you described, Joseph, going all the way from discovering what data lives in the environment all the way through to understanding that particular customer's business processes and creating policies for them and then helping them to implement. So the other thing that we do is we work with consulting firms like the big four companies, law firms, and other privacy experts who, even here locally, there's some consultants that are now emerging with strong privacy practices. And what we bring to the table is the technology aspect and advising on how technology can support across that journey. But the consultants, the law firms, they're really the ones who are able to help a business think through specific for them based on their business operations, what are the policies that they need to set in place, and do the data impact assessments where required, and really support with that implementation process. I'll maybe end with one last comment that there's a lot of different views around what should we be doing around compliance. Should we even bother to start? My apologies, my battery is, I'm just gonna switch on my plug. Yes, I was saying that there's varying views around should we be starting to comply? What should we do? As a company that went through this journey, what I would say is this: it's not a destination. You're not going to today wake up, start a data privacy program, and then reach a point of compliance and then stop. It is a process of continuous improvement. Even until today, after all the work we've put into our products and services, we're still iterating based on advice that we're getting from data protection authorities globally. And so take it as as has been shared earlier, that start the journey at least with the principles at heart of where can we start? Let's start looking where our business currently is and what are some of the things we can really start to do today.
Right.
Thank you very much, Ottilia. I'll just thank the rest of the panel and hand over to Maxwell.
Yeah, thank you. Thank you very much, Joseph. Thank you, Ottilia, Yvonne, and Engineer Bam. I just want to bring in the interest of time, I want to bring the audience into this and see if we can take as many questions as we can. I know we're already out of time, but this is definitely a very important conversation. And I want to start off first by this question from Lorna Nyandat. She's asking, Section 31 envisages a data protection impact assessment being conducted where there is processing of high-risk data. Joseph, you mentioned that you need to undertake a risk analysis. So the question is, can you shed some more light on what considerations would need to be factored in the risk analysis? Are you able to keep that brief and short so that we can see how we can cover as many questions as possible, please?
Okay. Again, I guess part of it is the type of information that you are processing, you know. So how much of it would be sensitive personal data, for example? And also, the other thing you need to potentially take into account is, you know, again, who is it disclosed to? So ultimately, at the end of the DPA, you're required to create a report. And so when you identify firstly the type of data that is being processed, then you get a sense of, you know, then what sort of controls do you then need to put in place in order to protect that information? So, for example, some of the tools that Ottilia mentioned around encryption. So you again need to assess, do you have the ability to encrypt and other tools such as pseudonymization? I struggle with that word. So it's really trying to get a sense of the more the type of a particular type of information you process, the greater the volume of that type of information you process, then the greater the risk. The more the number of purposes that you probably apply that information for, again, that can also enhance your risk exposure. And it's always a question of always understanding, have you gone back and either relied on consent or alternatively have another ground for being able to process that information for those further purposes. So that is in a nutshell is what how I would look at the DPIA. Maybe Yvonne and Ottilia might have some other thoughts around that.
Yeah, maybe just to add two other things to consider around that, because remember that the purpose is to consider safeguards, right? So what we're being asked is to increase your safeguards around how you're managing data. And the vast majority of us in this conversation would have third-party vendors that we're working with. So, you know, you would definitely need to consider, you know, which third parties are involved with the products and services that you're providing. Do they also have the requisite safeguards? Because you can't transfer the risk, you know, to that third party. The risk remains with the organization. So the third party consideration is a very, very important part of that. And also, you know, where are you getting the data from? Are you getting it from the source, or are you getting it from, again, a third party? Because that also increases the risk when you consider a third party, or rather a privacy risk assessment.
All right. Well, thank you for that. The next question is relating to cross-border movement of data. And I've seen this popping up quite a bit. So the question here from Kerry Karimi is asking, how does an organization deal with cross-border movement of data, or the perception that data is actually being moved by an organization? And especially if you look at this in the context of electronic health and or health or medical records, where some civil society groups, you know, have gone to case around this issue. And of course, the whole Huduma number, I think, is something that is fresh in our minds. So perhaps this is something that Engineer Bam could address for us, and then any of the other panelists can feel free to chime in. Engineer? You need to unmute your mic. Engineer,
I was trying to type some answers, some questions that came directly to me. So kindly just repeat for me the question.
Yeah, the question is about cross-border movement of data and the perception that, data is being moved from organizations across geographies. And the case that has been pointed out here is electronic health medical records. And of course, the whole aspect of Huduma number and whether, some of these could be shared with foreign organizations or foreign governments. Do you have a perspective on that?
I think there's a provision in the Act that gives the minister powers to allow other data to be moved out of the country. But I think the important thing is the adequacy, the requirement for adequacy, so that, and I think this has also come up in the discussion. For example, if you are going to move a patient, say, to India for treatment, the doctors in India may require their records. So I think that there'll have to be some maybe the DPC, when in place, could actually allow within that context that the data be moved to be able to accomplish what is required. I haven't read the Act in a long time, but I think there are some provisions that do allow exception circumstances under which the processing can be allowed.
Mm-hmm. Okay, thank you for that, Engineer. There's a question here regarding the need to, in terms of the Act being able to balance the protection of personal data while allowing deployment of groundbreaking technology solutions such as public cloud-based technologies which drive efficiency in solution delivery. What are your views on that? Maybe starting again with you, Engineer. What are your views on that? Because, the technologies such as public computing, and I believe this has been talked to as well, are critical in driving efficiency and, delivery. How do we balance that need?
For me, I think talking about cloud-based services, the issue of adequacy, I think, is important. Cloud services have been with us, data centers have been with us for a long time, and they've been processing information. And if you are offering a cloud service, then as a data controller, as a processor, then and you have the cloud is not in your jurisdiction, then you have to make sure that where that data is being processed in, where that cloud or the server is based, must meet the requirements must meet the adequacy requirements of the Act.
Mm-hmm. Okay. Any other comments on that from Ottilia, perhaps Joe?
Yeah. If I can chime in here, as in working for a company that's actually in this space, I actually feel that emerging technologies can support you to achieve compliance with data protection regulations. In fact, digitization and having content in digital format and also the security features of the tools that are available within cloud infrastructure services actually enable you to do it much easier than if you were working in your own solo on-premises environment or still leveraging hard copy or physical elements. So I actually think that cloud computing or or emerging digital technologies can support compliance with data protection. And the Act is quite permissive as well, as has been explained by Prof. earlier.
All right. Okay, great. I know we are 10 minutes over our time, but there's two questions that I'd really like us to very quickly address as we wind down. The first one is to you, Joe, and I know you touched this a bit on your presentation. The concern about children. With this advent of homeschooling, gaming, what are the key considerations that we need to take, both at an individual level and maybe even for organizations that are, providing this service when it comes to protection of children online?
Okay, I guess the basic proposition at law is that first, the issue of consent, seeking parental or guardian consent in order to collect and subsequently use that information. And then the idea that whatever use you're going to put to that information as an organization needs to factor in the interests of the child. Now, if I'm looking at it from the point of view of the parent, and especially, as you say, the homeschooling, one of the things I'll be looking at is the kind of technology that's being used to facilitate that homeschooling. And then asking yourself, what sort of safeguards does that technology that is embedded in that technology? And so that I make a decision then as a parent as to whether or not I'm comfortable with the information relating to my child being used within that technology, even for the purposes of providing that service. From the school's point of view, you also then, because you're going to have to give assurance to the parents or the guardians that whatever technology you're applying to provide the homeschooling service is safe, then you have those obligations as a data controller, where you need to then review the technology that you use to provide the educational service, so that it then meets those legal requirements. So that's one perspective. I hope it sort of answers the question, but I'm sure there's a lot more to that question that could be unpacked given time.
Yeah. And so the final question is really on so somebody here is asking, to achieve data protection, organizations will require partnerships. And they're saying that how can ethical hackers and security companies partner with organizations to help them achieve data protection? Anyone with a perspective on that?
Otilia, maybe, or Yvonne, I don't know. Or those who use red teams and blue teams in the organization.
I don't know, maybe I'll just give kind of my quick perspective on that. I think, data protection kind of historically was seen as, stopping companies from maybe over marketing to people. So you're blasting emails to people and kind of annoying, your clients. But I think now it does become more about the power dynamics and kind of the ethical conversation, starts to come into play here, because it does become, we do have to kind of view it through the lens of, are we ethically doing the right thing in the way that we're handling our customer information. So I think partnerships are important. I talked about it earlier in terms of, the partnerships that we have had to employ, as an organization. I think, it really would be a matter of, from a risk tolerance perspective, whether, those partnerships would actually be able to kind of build the kind of value that you'd be looking to build, as you consider, those various aspects of data privacy and data protection.
All right. Okay, great. Sorry, we've run out of time. We are almost 50 minutes over time. There are several questions that have come in. I just want to reassure the audience and those who've actually asked those questions that we will share answers to these questions when we send through the presentation and the recording for today's session. So rest assured that your questions will be answered. And I just want at this point to thank everybody. Really, everybody. Thank our panelists, Joe Githaiga from PwC, Otilia Piri from Microsoft, Engineer Daniel Obam from the National Communications Secretariat, Yvonne Muturi from Citi. I want, in closing, to invite all of you to take a quick poll that is coming up on your screen right now. It will take just 30 seconds. Please do give us your feedback. There it is. Just 2 questions, real quick, give us your feedback. And in closing, I just want to say that this has been a wonderful eye-opener. This is the beginning. As you can see, we all have a responsibility to our organizations and also to ourselves to make sure that we are compliant. And as we believe that as this Data Protection Act is rolled out and is implemented, there will be opportunity for us to engage in this discourse further, and that this is just the beginning, not the end of this. I sincerely want to thank all of you for turning up in great numbers, and really appreciate your time this morning. Thank you, be safe, and have a good day.